Hello, and welcome to the USDA, SNAP-Ed, and CACFP Civil Rights Training. All agencies that receive USDA, SNAP-Ed, and CACFP funds or whose partners benefit from CACFP funds and receive and use SNAP-Ed materials and lessons with their participants are required to receive this training. This training is required today so that all staff fully understand the federal laws and regulations regarding discrimination of our participants' civil rights. We will be focusing on the key points, but you will have the PowerPoint to read and review. Who needs to receive this training today? We all do. All our partners are required to receive this training annually in order to be compliant with the civil rights laws. It is our responsibility to protect the civil rights of the people we serve. This training will help you gain a better understanding of how to do so. New employees and volunteers must also receive this training before participating in program activities.
All partners must be familiar with their provider responsibilities. This will help ensure that the civil rights of all participants are protected and services are being provided in an equal manner. We must be compliant with all these responsibilities, or we risk having our federal funding cut. We will be reviewing each one of these today with you.
But first, we must gain an understanding of what civil rights are. Civil rights are personal rights or liberties guaranteed by the 13th and 14th Amendments that provide freedom from any form of discrimination. They require that all people are treated equally regardless of their race, color, national origin, religion, age, sex, spoken language, or disability. There have been many civil rights laws that have been enacted over the last 50 years, starting back in 1964.
The federal laws cited on the following 5 pages explicitly describe the laws that were enacted to protect individuals from discrimination due to their race, color, national origin, age, sex, or disability.
Why is this civil rights training important? It can be difficult to put aside one's personal life experiences and beliefs which can influence the way we treat a person or group of people. Therefore, this training provides us with some of the challenges we might face and ensures we are compliant with the law. We cannot discriminate, which is defined as giving different treatment to individuals purposely by neglect or by actions or lack of actions. We are not allowed to let prejudice or stereotypes interfere with equal treatment of an individual. Prejudice is defined as having a rigid and unfavorable attitude or oversimplified generalization about a particular group. We must strive to show respect and dignity for all.
Child nutrition programs were created to make sure that everyone has access to them and to eliminate any barriers to their participation. Participants also need to be fully aware of their rights and responsibilities as part of the program. This will help the program run smoothly and help the participants understand their role in your program and what rights they have if they are unhappy with the way the program is being run. It is essential that we treat all participants with dignity and respect, which are noted in this slide.
It is also important to allow individuals to participate regardless of their religious affiliations. We cannot choose to discriminate against a participant because of their religious beliefs. For example, if a program is being offered in a Catholic church, a person who is Muslim or Jewish cannot be told they are not welcome to participate.
This training will also help us understand if an action is considered discriminatory. Using the 4D test can help you decide that. Ask yourself if someone was denied benefits or services. Were their benefits or services delayed? Were they treated differently? Or were they given disparate treatment? Answering yes to any of these questions is a big red flag and could cause for civil rights complaint to be filed against your organization.
Any participant who feels their civil rights have been discriminated against has the right to file a complaint against our organization. We must provide them with the information on how to file the complaint. The complaint can be written out, filed online, or given verbally, and can remain anonymous if the complainant wishes. They should include details about the alleged event, location, and person or persons involved, and should be filed within 180 days of the incident. All complaints will be investigated at the federal level and will need to be forwarded to the state agency within 5 days of receipt.
All civil rights complaints must be documented in a log and maintained for 3 years. The log must be confidential and kept in a central location. Civil rights complaints are considered a very serious incident. Learning how to avoid them is the most important thing we can learn today. Let's review some modifications and accommodations that can be made to help people gain full access to our programming and to help avoid receiving a complaint. In the same way we accommodate children in the classroom with different learning styles and needs, we are also required to make accommodations for any challenges and limitations that may exist to our program, including people with a disability or people who have limited English proficiency.
A disability describes a person who has a physical or mental impairment which substantially limits major life activities. People with limited English proficiency are those who do not speak English as their primary language and have limited ability to read, speak, write, or understand English. Reasonable modifications must be made to provide services to both groups of people. Failure to provide meaningful access will be considered discrimination. What do you think would be considered a reasonable modification?
All modifications must be funded by our organization and never by the participants. Examples of appropriate accommodations include modifying materials to use braille or large print, having access to interpreters, installing ramps for individuals with wheelchairs, providing handicap parking, adjusting table height, or providing food alternatives to those with allergies.
Types of accommodations for people who have limited English proficiency can include using translation services for vital documents, using qualified, competent language resources and interpreters, using manipulatives or demonstrations to help someone better understand, or using materials with pictures instead of words. Children should never be used as interpreters. Having a staff training regarding on how to provide LEP populations with meaningful access is paramount for a successful program.
Let's put into action a little of what we just learned. A Spanish-speaking person requests an enrollment form. The staff member does not provide a form because it is only written in English. Is this a civil rights violation? Yes, this is a civil rights violation. The person's limited English was not accommodated by the program, and they were denied an opportunity to enroll.
A reasonable diet accommodation or modification is any change or alteration in a program's policies, practices, or procedures. Having a clear line of communication with the participant and their family will have the greatest effect on their access to our program. Program operators must find ways to provide meals that are equally balanced and served together as a group. Accessibility modifications may be done to the facilities to make them more accessible for all individuals.
Accommodations for diet restrictions should be made on a case-by-case basis and should follow recommendations by the student's medical team. Participants may not be charged a fee to provide this accommodation. Types of diet accommodations can include serving lactose-free milk or soy milk, providing alternative fruit, for fruit allergies, pureeing foods, providing a lunchtime aid, providing gluten-free breads, tracking food intake for students with diabetes, or accommodating vegetarian eaters by serving credible meat alternatives.
In order for us to provide and be reimbursed for the accommodation, we must have a medical statement on file from a recognized medical authority, which can include a physician, physician assistant, certified registered nurse practitioner, or dentist.
The medical statement will need to include a description of the participant's impairment, how it restricts their diet, and what needs to be done to accommodate it. Identifying food alternatives or foods that need to be omitted should also be included. If the medical statement is unclear, clarification must be obtained so a safe meal can be provided. Medical statements do not need to be updated each year unless changes need to be made. Program operators should confirm that no changes need to be made on an annual basis.
The overall goal for providing accommodations is to have children participate together in meal times and to give all children access to CACFP services and nutrition education. Medical statements are required if a modification request does not meet the program meal pattern requirements. If a modification can be accommodated within the program meal pattern, a medical statement is not required. For example, cutting up fruits or vegetables into smaller pieces or providing different portion sizes.
Not only do we need to provide accommodations and modifications to our program and the materials we use, we also need to maintain program compliance in order to continue receiving funding. What do we need to do in order to maintain program compliance for our grants? There are 5 guidelines that need to be followed, and they include 1. Assurances, 2. Public notification requirements, 3. Racial and ethnic data collection, 4. Participating in compliance reviews, and 5. Resolution of non-compliance issues.
Program compliance will be analyzed during scheduled and unannounced visits by the state agency. If non-compliance issues are found, steps must be taken immediately. Not correcting an issue of non-compliance will lead to suspension or termination from the CACFP.
A civil rights assurance statement must be incorporated in all agreements between federal, state, and local agencies. All retailer and vendor agreements must also include an assurance of non-discrimination. Putting a non-discrimination statement on all materials is also required, as well as displaying the "And Justice for All" poster in all of our facilities.
There are two colors of the Injustice for All posters. They both need to be posted in a place that is visible to all program participants.
The non-discrimination statement must be on all information, materials, and resources, including websites, brochures, handbooks, and enrollment forms. Conveying a message of equal opportunity is very important.
The non-discrimination statement serves two purposes. It lets participants know that all forms of discrimination are prohibited during our programming, and it also provides information on how to file a civil rights complaint. The following two slides are the non-discrimination statement that should be found on all materials.
The second area of program compliance is having a public notification system. The purpose is to inform all potentially eligible persons of program availability, complaint information, and the non-discrimination statement.
The administrator that oversees the pre-K site must notify the public about CACFP and nutrition education programs available. As a sponsor, we must provide information to the public about our availability, hours, eligibility, and services rendered to the community at large.
The third area of program compliance is about the collection and use of racial and ethnic data. Data collection is mandatory. Any agency who gets funding needs to collect information about their participants, and that data must be maintained for 3 years. The data is used to determine how effectively FNS programs are reaching potentially eligible people, to identify areas where additional outreach is needed, to assist in the selection of locations for compliance reviews, and to complete required reports.
Data must be collected by using a two-part question, asking the participant for both their ethnicity and their race. Those who receive the USDA funding are required to receive this information from its partners.
The data must be kept in a confidential file and must be restricted to authorized program personnel only.
How do we collect racial and ethnic data if the applicant chooses not to provide their racial and ethnic makeup? The data collector can use visual observation to secure and record the information if needed. However, it is always best that the applicants self-identify their race and ethnicity. The data collector cannot change or challenge a self-declaration made by the participant.
Two questions that we should never ask from a participant is their immigration status or their social security number. That information is only required when someone is applying for benefits, not for receiving nutrition education.
Let's review what we just learned about our program compliance responsibilities. Your community has a large Hispanic population, roughly 60%. Only 5% of your participants are Hispanic or Latino. What types of outreach would you choose? A. Make program materials available in Spanish. B. Reach out to community organizations in the Hispanic community. C. Partner with local social service agencies. D. None of these. Or E. All of these. Answer: E. All of these. The important thing is that you evaluate the data you collect to be sure that your program is reaching as many potentially eligible families as possible.
A family does not want to identify their race or ethnicity on the income eligibility application, but you know you are required to collect this data. What should you do? Number one, make a visual identification. Number two, look through your records to see if you have this information already. The preferred method is self-identification. You may not ask anyone outside the program, such as friends, about another person's ethnicity or race.
Part 4 of our program compliance involves participating in compliance reviews. All agencies must take part in these reviews to make sure they are following all civil rights compliance guidelines. Any significant findings must be provided in writing to the entity.
There are three types of compliance reviews: pre-award compliance reviews, post-award compliance reviews, and special compliance reviews. Pre-award reviews occur before federal financial assistance occurs, and post-award occurs routinely to make sure agencies are doing their part to maintain civil rights compliance.
Special compliance reviews may be scheduled or unscheduled. They usually occur as a follow-up to previous findings of noncompliance, or if there is a pattern of complaints of discrimination.
Some questions that may be asked during your compliance review include: do printed materials contain the non-discrimination statement, and are they available to all? Is the "And Justice for All" poster being displayed appropriately? Is data on race and ethnicity being collected appropriately and kept confidential? Are participants being advised of their right to file a civil rights complaint? Are reasonable modifications being made for people with disabilities?
What do you do if you receive a finding of noncompliance? Steps must be taken immediately to correct the error or funding will be discontinued. Producing a VRA is often one solution to a finding of non-compliance.
What is a VRA? A VRA is a voluntary resolution agreement and is often made to address areas of non-compliance. This agreement can be made between multiple parties and can be used to close out a compliance review. They can also be used if your organization is in violation of a civil rights law. The resolution will require that remedial actions be taken in order to prevent future occurrences within your organization. Not complying with the VRA will result in funding being cut totally. To give an example of a VRA that took place in Pennsylvania in December of 2019, this complaint was filed regarding not receiving benefits in a timely manner due to a lack of appropriate language services. This resulted in the organization being monitored for the next 24 months and making many changes to their programming and materials. They were required to complete an assessment of their community's needs, provide new updated materials in Spanish, and provide training for all of their staff.
There are times that a participant may feel they have been discriminated against and make a complaint against your organization. If this happens, there is an entire set of procedures that need to be followed. An investigation into the matter will take place and a resolution will need to be agreed upon. A new policy or training will be put in place to help avoid any future issues.
There are skills that we can learn to help us be more effective with our audience. Having good customer service and follow up shows we support our partners. It also helps to strengthen our empathy for their situations and shows we care for participants and what they are experiencing. If a conflict does arise, it is important to identify what the problem is quickly and come to an agreement that gains the approval of the participant. Following up with the participant helps build a strong relationship and allows them to know we are willing to right our wrongs.